Good afternoon, everyone. Thank you for joining our webinar today. I'm Emma Waldron, WCVA's Risk and Procurement Manager, and I am also WCVA's Data Protection Officer. So this is the 6th webinar of the Desktop Data series that we've been running, and these sessions have been arranged to help you prepare for the new General Data Protection Regulation, which comes into place in May 2018. Normally, we have Bethan Bonsall from the ICO joining us, but today we have Helen Thomas from the ICO.
Hello.
And Helen's here to discuss subject access requests. So today's session should be about 20 minutes, and there'll be an opportunity for questions at the end. Please feel free to add any questions to the chat pane during the session, and we'll aim to answer them at the end of the presentation. There will also be an opportunity to share your comments by completing a short survey, which we'll share the details of on the final slide. Okay, so over to Helen.
Thank you. Welcome everybody. Today's webinar is about subject access requests. A subject access request is when an individual uses their rights within the Data Protection Act to request a copy of some or all of the information that an organisation holds about them. The request may be from staff, volunteers, service users, customers or anybody else. Because subject access request is a bit of a mouthful, they're often called SARs, and I will be using that term today. However, before I get started about SARs, I want to introduce the ICO. We are the Information Commissioner's Office. The Information Commissioner is the regulator for data protection across all parts of the UK, and she has offices in Scotland, England, Northern Ireland and here in Cardiff. The Cardiff office operates a bilingual advice service. Our contact details are on the final slide. Let's have a look at the right of subject access. Subject access is a fundamental right for everybody under the Data Protection Act. In practice, it means that you can contact any organisation of any size in the UK and ask to be given a copy of all the personal data they hold about you. By personal data, we mean any information that allows you to identify a living individual, or information which perhaps when put together with other data already available would enable you to identify a living individual. The data can be recorded in any format, electronic or hard copy. Hard copy data will be in scope if it is stored, or waiting to be stored, in a structured filing system, or waiting to be loaded on a computer. Remember, it's not just written information, but it also covers photographs, voice recordings, CCTV images, and biometric data, anything that enables you to identify a living individual. It's an absolute right to make a SAR. Everyone has the right to make the request to any organisation of any size in any sector. But it's a qualified right to be provided with the information. And as we'll see later, there are some occasions, but not very many, when information may legitimately be withheld from disclosure. Under the current law, you have 40 calendar days to respond to a SAR, but be aware that the law is changing next May, and from then you will have only 1 month in most cases. However, there will be some facility to extend the response time by up to a further 2 months when the request is complex or numerous. So let's have a little look at 10 simple steps that you would need to take if you are responding to a subject access request. Step 1. Is it a SAR? Make sure that all of your staff can identify a SAR. Know that time is crucial and know who in your organisation is responsible for answering. It is also important that all staff can advise people how to make a SAR in case someone asks them for a copy of their personal information. All of the examples on this slide are valid SAR requests. The requester does not need to refer to the Data Protection Act, and sometimes they refer to other legislation. It doesn't matter. It's your job to handle all requests for personal information in accordance with the Data Protection Act. Crucially, a SAR must be made in writing. It could be any written format, handwritten, email, social media, etc. Please indicate in the chat pane by typing yes or no if your organisation has received a SAR.
Okay, so let's just wait and see then what people are typing in. So 3, so 4, 5, majority seem to be that people haven't received a subject access request. Just one organisation then has received a subject access request. Okay, thanks for that.
Step 2 is to confirm the requester's identity. Clearly, if you give out the personal information involved in a SAR to the wrong person, it could be a harmful mistake. So it's important that you check the requester's identity. If you know the person well and they have handed you the request, then this is going to be sufficient assurance. But if you receive a request where you cannot verify the requester, then you should ask them to supply you with some evidence of identity. Sometimes someone may make a request on behalf of another person. In order for this to be legal, the proxy would need to give you evidence of one of the following. For example, if the person lacks capacity, the proxy may be able to show you either a power of attorney or a court of protection authorization, confirming that they are acting as a deputy. Or, if the data subject has full mental capacity, they will need to provide a letter specifying that they have asked the proxy to act for them. And of course, parents can act on behalf of young children. The Data Protection Act does not set a minimum age at which children or teenagers can exercise their rights, and what is known as the Gillick process applies. This means that those working with the child or teenager should make an assessment of their level of maturity and ability to understand the impact of what will be released. The ICO rule of thumb is that this approach should be taken where the requester is aged 12 or above, but each case needs to be taken on its own merits. Step 3. Do you need any more information? Is it clear what information the requester is seeking? If not, you may need to ask for more information to help you identify what they want. But remember, you cannot ask why they want it. In any case, you should ask for identity or other additional information promptly. Under the Data Protection Act, you do not have to charge for subject access request, but if you wish to, the amount you can charge is set at £10. However, be aware that the Data Protection Act is being replaced on the 25th of May next year by GDPR, and as from that date there will be no provision to charge for routine SARs. You will, however, be able to charge a reasonable administration fee for, quotes, manifestly unfounded or excessive requests, particularly when they are repetitive. Once you have the request, confirmed identity and any fee, the clock will start ticking for your 40 days to respond. Remember that as from next May, this will reduce to 1 month in most cases. Step 5. Do you actually have the information the requester is seeking? And if so, can you find it? You will need to make reasonably extensive searches, for example, including computer files and emails, CCTV, voice recordings, etc. Also, remember to check backup and archive disks. Remember that hard copy files in any structured filing system, or waiting to be filed or waiting to be put on computer, will also need to be searched. It is definitely in the organisation's interests to have good quality records management so that you only hold what you need and you can find it easily. Step 6. As a general rule, you must supply the data exactly as it was on the date of the request. You must not rewrite history in the way that our slides seem to have done since we last went through this. The only exception to this is you may need to include routine updates that you would normally have made. Think, for example, about a bank statement that gets updated after every transaction. What you most definitely cannot do is delete data to prevent its release, regardless of how embarrassing or inappropriate it is. When the law changes next spring, this will become a criminal offence. Take the opportunity to make sure all of your staff understand that there are no excuses for unprofessional comments in records or emails. If you don't hold the data, write back and explain this to the requester, telling them what searches you undertook to reach that conclusion. Sometimes when somebody makes a SAR, it'll involve the data of other people. These can be difficult to process. No one is entitled to anyone else's personal data, but sometimes personal data can belong to more than one individual. For example, a witness statement about a disciplinary matter would probably identify the witness as well as the employee being investigated. In these situations, please refer to the ICO guidance on handling SARs. That will guide you through the following steps. Firstly, you need to decide whether a third party is identifiable from the requested data. In addition, you need to think whether the requested data might be combined with other available information in order to identify someone. If someone is identifiable, are you under any duty of confidence? For example, this might apply to records of counselling sessions. And again, if somebody is identifiable, do you have the third party's consent to disclose the information? You're not obliged to do this, but depending on the request, you may decide it is appropriate to simply ask the third party if they would consent to their data being released. There are rare occasions when you may decide to disclose someone's data without their consent. Our SAR guidance explains this. A practical way of handling third-party data is to redact or anonymize the text. Remember, if you use a marker pen to black out text, it's important to photocopy the page again before disclosing, as the marker pen can be read through when held up to the light. Every request that includes third-party data will be different, so there are no blanket rules. Use the guidance on our website. Make sure you record the reasons for your decisions to withhold or disclose. This will be helpful for your organisation's learning and will also be needed as evidence if the case is referred to ICO. Don't forget to explain your reasons for withholding any information to the requester. Step 8. Considering exemptions. There are a number of reasons why you may legitimately decide that some data should not be released in response to a SAR. Here's a list of some that may be useful to the voluntary sector. Employment references are a slightly odd exemption. References are exempt from release by the organisation that provided them, but not by the receiving organisation. So you may prefer to disclose whichever end of that communication chain you are sitting. Crime and taxation. Information that would prejudice the prevention and detection of crime, the capture and prosecution of offenders, or the assessment or collection of taxes is exempt from disclosure. Management information. Personal data processed by an organisation for the purposes of management planning or forecasting is exempt from disclosure to the extent that that disclosure would harm the business. The exemption for legal advice and proceedings can only be used for information covered by legal professional privilege. It must not be used for any other information. Remember, you cannot take the applicant's motive into account, so whether the request is in connection with any actual or potential proceedings is irrelevant. There are additional exemptions and other provisions that apply to social work, health and education records, mainly in relation to safeguarding. If you process any records in this category, look at our SAR guidance for more information. When the law changes next May, you will have a choice about how to respond to a manifestly unreasonable or excessive request, particularly when they are repetitive. You can either charge a reasonable fee, taking into account the administrative cost of providing the information, or you can refuse the request. If you refuse, you must explain why to the individual, and tell them about their right to complain to the ICO or go to the courts. Step 9. Think about intelligibility. Organisations must explain any unintelligible information that is to be released in response to a SAR. People often ask if they have to translate SARs into Welsh or English. The Data Protection Act does not require this, as the languages are intelligible. However, your organisation may have a Welsh language policy to guide you. Some organisations prefer to do any translation in-house, particularly if the information is complex, rather than run the risk of poor quality translations leading to confusion. The approach to reasonable adjustments is similar. For example, someone may request their information is provided in Braille. It is not a matter covered by the Data Protection Act, but your organisation will have obligations and policies guiding your approach. Whilst the ICO has no formal powers over translation or reasonable adjustments, the aim of the Data Protection Act is to increase transparency and trust with the people whose data your organisation relies on. So we would always encourage organisations to be as helpful as they can in enabling people to access their data. And the final step, preparing the response. Requesters have a right to receive a copy of their information in a permanent form, but there are situations where you may agree with them to come in and view the data on your premises. The requester should receive a cover letter, including a description of the personal data you hold about them, the purposes for which you hold it, and the organisations, or at least the categories of organisations, that you disclose it to. In practice, many organisations provide a copy of their notification statement from the ICO Public Register, which covers all of these points. Your data protection procedures should include facility for internal reviews in the event that the requester is not satisfied with how you have handled their request. You need to tell them about their right to request an internal review in your cover letter. You also need to tell them about their right to refer the case to ICO. But note, we generally don't accept cases that have not exhausted the organisation's internal review process. Keep records of all SARs and of your decision-making processes. This is good practice now and will become a legal requirement when the law changes next May. Congratulations! That's how you process your first proper subject access request. Oh, excuse me, sorry. Please keep in touch with us by subscribing to our newsletter or looking at our website. Throughout the webinar, I've referred to guidance from the ICO, and our website at ico.org.uk is packed with information about data protection matters, so please do take a look. Also, here are the contact details of the Cardiff office. Many thanks for listening.
Thank you very much, Helen. That was a very clear and good overview of subject access requests. Much appreciated. Okay, so over to the participants then. Do you have any questions for Helen? And if so, if you'd like to start typing them into the chat pane, that would be great. I just want to reiterate a few important points, really. So Helen and I were talking a little bit earlier before this presentation on the importance of ensuring that all your staff are aware that a request for information held on them is a subject access request. So we were going through that.
Yes, it's really important that if quite often service users might make quite an informal inquiry, like, is it possible to see my record, or would it be possible to have a copy of this letter or that letter? And it's really important that staff understand that the sort of legally binding way for those requests to go in would be as a subject access request. So if they advise the person to write in to the organisation and make that request, then that individual gets all of the rights and protections of having made a request through the Data Protection Act.
Brilliant. Okay, and just to confirm or reiterate really that there's 40 days, the 40 days start after the identity is confirmed and, if applicable, payment is received. But note that under GDPR, May next year, it's 1 month.
Absolutely, yes. It drops down to 1 month. and we are currently waiting. There is a data protection bill in the House of Lords at present, and we are waiting to see if that will give any clarification about exactly how long 1 month is and whether it's at 28, 29, 30 or 31 days. So if I was you, I would plan for it being about 30 days for your planning purposes.
Yeah, that sounds reasonable. Okay, thanks, Helen. And then we've got some questions coming through. So there's one from Tina. How long should we keep things like staff files for once they have left?
Well, we don't have a specific timeline. What you need to think about with all of your filing is, firstly, what does the law require you to do with particular files? So staff files will vary depending on whether you've got, for example, pension scheme obligations for those individuals. So first look at what your legal duties are as to how long you keep information. Secondly, look at what is good practice in your sector and see whether perhaps there's any professional guidance or sectoral guidance about how long you should keep records. And then the third question, if those two haven't provided an answer for you, is simply how long does your organisation need to keep that information for? And those are the three layers that we would go to if a complaint came to the ICO about the length of time information had or had not been retained. That's the approach we would take. What does the law say? What does good practice in that sector say? And number three, what justification can the organisation give as to why they made the decision to keep it for that length of time?
Excellent, that sounds very clear. Thanks, Helen. Okay, and then next question from Helen. In terms of costs for dealing with requests, would it be reasonable for this to be in line with freedom of information costs?
I think it's a little early to say. I mean, it might be, but I think that might be something we get a bit more guidance from this data protection bill about. And it is something that I believe the ICO will produce guidance on nearer to the time. But that general approach where you can only charge for the costs incurred in actually getting the data will apply. And also, if you like with FOI, it's going to be really important that you will not be able to charge people a fee or reject requests just because your filing system isn't very good and it takes a long time to find things. It's got to be because the request itself is particularly voluminous or complicated.
Great, thank you, Helen. Okay, and then a comment there from Ewan. Thank you, Ewan. Okay, so there don't appear to be any more questions. So at this point, I just want to let you know that you feel free to share all presentations and videos from the desktop data series with your colleagues and networks. Slides will be made available to you after this session. We hope that you found it useful today and we value your feedback. There is a link on the slide there. We're always looking to continuously improve the delivery of webinars and online learning, so your support there would be much appreciated. Our next session is on data protection for trustees, which will be held at 2 o'clock on Monday the 20th of November. And in the meantime, if there are any topics that you'd like us to cover, please get in touch. And we look forward to you joining us again next month. Many thanks. Bye.
Bye.